Hey everyone, Harry here. It is January 16th, Martin Luther King Day. So I thought it would be fitting to talk a little bit about current issues in the legal landscape that really go to the heart of the kind of national challenge that Reverend Martin Luther King Jr. issued to the country to realize the promise of equality for all and where things stand. All right. You hear again and again, I think, as cases come to the Supreme Court about the Voting Rights Act, and in particular, hear that the Supreme Court has gutted or overruled in judicial decisions sections 2 and sections 5 of the Voting Rights Act. What's that about? I thought it would be useful for everyone to just spell it out, even though it's a little legal, a little arcane, so hold on. All right. After the Civil War, we passed the 14th Amendment, and the 14th Amendment has a very important provision at the end, a section that gives Congress extra powers to enforce the provisions of this act. The 14th Amendment guarantee of equality, the 15th Amendment guarantee of equal rights for voting. And the Congress has used this in different ways, including, by the way, its early efforts where there's really no doubt pointedly race-based and race-conscious to try to elevate the status of former slaves to full participants in the democracy. So the idea that the 14th Amendment is colorblind is very hard to square with its history. Okay, but using this Section 5 power, Congress passed the Voting Rights Act in 1965. It comes on the heels of the 1964 Civil Rights Act, probably the single most important piece of civil rights legislation ever in this country. But then that act did not really address voting rights. So now in 1965, the Congress passes and Lyndon Johnson signs into law the Voting Rights Act of 1965. A lot of stuff in there, but let's just try to focus on the essential as it especially relates to the current battles in the court. Probably the most important provision of the Voting Rights Act was Section 5, again, of the Voting Rights Act, not of the Constitution. And in combination with Section 4, Section 5 said that it identified a number of jurisdictions that had really acted to disenfranchise minorities. A lot of sort of Jim Crow stratagems. Oh, yes, African Americans can vote, but we're going to have a property requirement or poll tax or reading test, all kinds of things that everyone understood was an effort to get at what they had previously done before the 14th Amendment, but sort of couch it in non-racist sounding terms, but everyone understood what the game was. Okay, so Section 5 said for these jurisdictions, mainly but not exclusively in the South, anytime you monkey with your voting procedures, let's say you can do direct mail, or let's say you close the polling times or shorten them in certain communities, or any kind of adjustments, you need to get pre-clearance from the Department of Justice. You need to run that by the Department of Justice and make sure that it doesn't have the effect of disenfranchising colors of voter. You can imagine how this has always stuck in the craw of especially, state officials. We've got it's not simply that, the law applies to us, but that we have to come on bended knee to Washington to get permission. Okay. However, they did, and then repeatedly, an important point here as well, the Congress reapproved it. They had another chance. They said, yep, we still want to have this pre-clearance in place for these jurisdictions. And truth be told, the political dynamics were such that it was hard for Congress not to approve it, but they did again and again, including in 2006. And now in 2013 comes the Shelby County versus Holder case, in which the court, in an opinion by Chief Justice Roberts, basically strikes down Section 5 as unconstitutional. And why and how? What they say is, yeah, we know Congress has approved it and reapproved it and we approved it, but it's just been too long. And to quote Chief Justice Roberts, it's a sordid business, this sorting by race. And we're just going to say it's unconstitutional. Maybe Congress can take it up and pass a whole new thing with new findings. Why in 2022, it's like the bad old days of 1965 when they made those findings. But unless and until they do, Section 5 is unconstitutional. There's just not a good enough showing that there's this kind of invidious discrimination on the part of Southerners anymore. Now, you can understand maybe where he's coming from, but it is a very strange judicial decision for the Supreme Court to basically say, nah, we don't have a good enough tie anymore. But that's what happened and why it's very controversial. Boom, the most important provision of the Voting Rights Act, gutted, gone, called unconstitutional. Now, Section 2. Section 2, again, of the Voting Rights Act, not of the 14th Amendment, is a general prohibition on discrimination and on practices that disenfranchise. And there was a whole bunch of back and forth early on about whether that was an intent test. You had to show that people who enacted them were trying to disenfranchise, or a results test. And just given the plain meaning, the court opted for a results test. So we now have, even though Section 5 special medicine for the folks from the jurisdictions with egregious histories was out the window. At least there was this general kind of prohibition, which you couldn't get preclearance, but you could sue under and sue after the fact, etc. Until 2021 and the case of Brnovich v. Arizona, basically, and an opinion by Justice Alito, who went a long way. The Shelby County v. Holder eviscerates Section 5. Brnovich just cripples, takes 3 legs away from Section 2. How? Well, Alito says, you got to think about everything out there, including the, bromide or the mantra from all the states who have been doing this. We're trying to get at election fraud. There is an election fraud, of course, but courts don't normally second guess and require evidentiary proof from jurisdictions and states. So basically, it sets up a totality of the circumstances test. In the case actually of Brnovich, Arizona had a provision that said you can't vote from out of precinct, or you can't vote partially, things that were classic stratagems to make it harder for voters of color. And the court upheld it with a kind of play in the joints, mucky totality of circumstances test, which basically said you look at everything, including how strong the impact on voters of color. It used to just be it makes it harder. Now, how much harder does it make it, and why is the state doing it? And maybe they are really worried about fraud, etc. So it just hugely empowers the kind of position and talking points of states in the modern day who are employing these stratagems, maybe not even in racially invidious ways, but in ways designed to make it harder for people of color to vote, basically because that's going to take away votes from Democrats and gives them the Republicans. Okay, so a bit legal, but now when the courts or anyone else talk about how the Supreme Court has really gutted the 2 most important provisions of the Voting Rights Act of 1965, what and how they did. So there you have it. I just thought, it being Martin Luther King Day, that I wanted to just finish with just reading a passage from my favorite of his writings, the letter from the Birmingham jail. I think of it, it's magnificent. He's while in jail, he's addressing a whole series of supposed colleagues, home team folks, clergy who have been telling him, you can't do this, you can't break the law, etc. And he gives such a thoughtful and considered and high-minded account of justice, racial justice, but justice generally. So to me, kind of the way that the second inaugural by Lincoln is the masterpiece, and Gettysburg Address and other things are very good. I Have a Dream, incredibly stirring speech, but I really love the letter from the Birmingham jail. And if you have a few minutes to just read it today would be a fitting day. And I will just close by reading it with no pitches of any kind or telling you to go to Patreon and the like. But here I would just like to take what Martin Luther King said to a clergy member, supposedly an ally, who was saying to him, look, take your time. You're going too fast. It's taken Christianity almost 2,000 years to accomplish what it has. The teachings of Christ take time to come to earth. And this is what Martin Luther King Jr. says in response. Such an attitude stems from a tragic misconception of time, from the strangely irrational notion that there is something in the very flow of time that will inevitably cure ills. Actually, time itself is neutral. It can be used either destructively or constructively. More and more, I feel that people of ill will have used time much more effectively than have the people of goodwill. We will have to repent in this generation, not merely for the hateful words and actions of the bad people, but for the appalling silence of the good people. Human progress never rolls in on wheels of inevitability. It comes through the tireless efforts of men willing to be co-workers with God, and without this hard work, time itself becomes an ally of the forces of social stagnation. We must use time creatively, in the knowledge that the time is always ripe to do right. Now is the time to make real the promise of democracy and transform our pending national elegy into a creative psalm of brotherhood. Now is the time to lift our national policy from the quicksand of racial injustice to the solid rock of human dignity. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.